Um,
Okay.
okay, just stay on the line. Can you hear me now? Uh, what's the sound like, Betty?
The sound is perfect, sir.
Okay, good. All right. All right, Betty, shall I get started?
Yes, please, Judge
Okay.
Hussain.
All right. Yeah, I've got a long program today. I might take a full 3 hours to complete it. Okay. Good morning, everyone. Welcome to this course. The course is all about helping you to do court appearances. Now, you've all heard by now that some people are born to be good trial lawyers, while others are not. You must have heard your colleagues say you either can cross-examine or you can't. It's as if you were born to be a trial lawyer. Now that's absolute nonsense. Um, we have proven over the years that you can train and practice and become a very good trial lawyer. You don't have to be born with some talent that some have and some don't have. That's the good news. The bad news, of course, is that to get there, to be a good trial lawyer, requires hard work and application. So you reap the benefits if you're willing to work. Otherwise, you will either be a mediocre lawyer or you'll find yourself staying away from court altogether. Now, I'm going to present this course for each area of the course. It will be split into 3 parts. I'm going to talk about, firstly, what does a judge look for? Now, let's get one thing straight. You go to court, in our courts, adversarial system, you go to court in order to persuade the judge to accept your client's version of what happened. Then you win. But if you can't persuade the judge, you lose. There's a technique in how you present the judge, present your case to the judge so that the judge accepts it. That's what you want to do. The judge must accept your client's version. That's the trial lawyer's job. So I'm going to talk about what judges are looking for. Now, obviously, if you know what the judge is looking for, you will adapt your technique accordingly so that you are focused on convincing the judge. That's the main thing. The second thing I'm going to talk to you about is preparation in order to make you a more effective trial lawyer. You cannot possibly lead a witness in chief, nor can you cross-examine your opponent's witnesses if you are not well prepared. And get one thing straight. If you are not well prepared, judges have this uncanny ability to see it and to pick it up at an early stage. I can tell you, I spent many years on the bench, and it didn't take long to see that the lawyer is not really well prepared. Now, once the judge sees that you are not well prepared, they stop taking you seriously. So they're not listening to you most of the time. And that doesn't make for persuasive presentations. Now, the techniques I'm going to talk about are relevant not only to your normal trial courts, but they are relevant in other courts as well, such as the labor court, those of you who do labor work. I know there are many of you here who practice in the special tax court. I sat in the special tax court, and I can tell you that the techniques you see here will help you if you are going to appear in the special tax court. It helps you in the competition disputes. So generally, where we are dealing with adversarial resolution of disputes, these techniques are relevant. So that's the second part, is the preparation. The third part is the technique in actually presenting. How do you lead a witness effectively in chief? What is the method? How do you formulate the questions? And the third, and how do you handle cross-examination? So it will the presentation will follow that pattern. But let us start with something that may seem obvious, and that is, to a trial lawyer, and I'm telling you, don't do it. Just don't put your foot in a courtroom if you have not first mastered the facts of your case. That's the key. Now, trials are about facts. They're about people. It's not about the law. So if you have not mastered the facts of your case, how on earth are you going to present it to a judge? And I've got a quotation here from Judge Rolf Hamilton, who's an English judge. He said, "Get the facts right, and the law will look after itself." And I'm telling you, in a trial, the law is the easy part. You succeed or fail because of your handling of the facts. Now, before we get going, there are three principles that I want you to bear in mind. When you go to a trial, be it a civil case or a criminal case, a tax matter, labor, doesn't matter. Your story must be about people and events. The judges are people who are concerned about doing the right thing. I know some of the judges don't behave like that, but most of them are concerned about doing justice, about doing the right thing. But a judge relies on the parties to present the evidence. So your job is to assist the judge. You are not there to merely go through the motions of putting your case before the court. You must remember why you are there. You are there to assist the judge. And to assist the judge in doing what? To find in your favor. You have to tell the judge what happened. Present the incidents. Present the people. Present the facts. And why do you do all this? I told you, to persuade the judge. But part of the persuasion is when you present the facts in order to support your final argument. So when you get on your feet to argue the case, that's when you want to be supported by your facts. If your facts don't support your argument, you really end up looking like a fool, because you'll make a submission and the judge will say, "But where do you get that from? Refer me to the evidence," and you'll have a problem. So that's the first principle. Second principle is that in our courts, judges are not inquisitorial judicial officers. In other words, they don't get involved in the evidence. They don't go and they don't actually investigate the matter. The judge can only make findings, and those are findings of fact, from what you as the lawyer presents in court. Now remember, a judge cannot apply the law before making a finding of fact. So when you go to trial, there's always a dispute of fact. You have to help the judge to resolve that dispute of fact in your favor, and only then go about applying the law. So if you get a poor result, it's mainly because you didn't provide the judge with enough evidence to make a finding in your favor. The third principle is that trials are much more than merely putting your client's version on record. You must have seen this in court, where the lawyer stands up and says, "My lord, I call my first witness, Mr. Smith." So Mr. Smith gets into the box, and the lawyer, in quite a boring tone, says, "Mr. Smith, where were you on such and such a date?" So Mr. Smith tells the judge he was in a certain place. And now the lawyer says, "Tell the court what happened." And the witness drones on, keeps talking while the lawyer is shuffling papers, looking disinterested. Well, trust me, that's not good advocacy. You are really going to lose your case. Your job is to organize the facts, present them in a logical, persuasive sequence. You must present the judge with an organized story that the judge will accept, that the judge will find to be persuasive. And I'm going to show you how you do that. Okay. Now let's look at what judges are looking for, the basic stuff. Now the story is told by witnesses who have personal knowledge of what happened. Now, here's the first thing. Judges like hearing witnesses who have personal knowledge. That is why we have rules against hearsay. The judge wants to hear from someone who has personal knowledge of the incident or of the transaction that they're testifying about. The version must account for the undisputed facts, which facts support the version of the witness. So, what this means is that when the judge listens to the evidence, the witness's version must take into account those facts that are not in dispute. And the facts must support your case concept, meaning the witness must support your client's version of what happened. Now remember, that case concept is something that you would have pleaded. At the end of pleadings, at the end of all the pre-trial conferences and so on, you would have agreed with your opponent that this is the dispute or issue that we will take to trial. Okay? Now you have to provide the witnesses to tell the judge to find in your favor. Judges want to hear credible witnesses, and I'll come to that in more detail. The version is supported by relevant detail. Now, on the material facts that you need to present to the judge, you cannot be vague. One of the ways in which the judges assess evidence is to listen and to listen out for details. You know, they say the devil is in the details. When you give a vague explanation, your witness gives an explanation that has gaps in it, the judge doesn't really get it. That's not convincing. The version must be probable in relation to the circumstances of the case. Now, those of you who have attended the previous sessions will know that you cannot go to court and present any witness whose version is improbable. In other words, it is not likely to have happened. It's implausible. Now, the standard of proof is on a balance of probabilities. So if your version is improbable, the judge is not going to balance it with anything. He's just going to reject it. So don't go to court with a rubbish version. You must present the version in a chronological sequence. Now, why is that the case? You see, sequencing facts is what gives meaning to the facts. It makes the listener understand what is going on. If you present the facts all over the place, you are not going to succeed. We now insist that lawyers must present the facts in a chronological sequence, and I'll say more about that later. The version that you present must consist of admissible evidence. In other words, the rules of evidence apply. So each time you call a witness to testify, that witness and the version they present must comply with the rules of evidence. So for example, if the witness gives hearsay evidence, that will be struck off. The version or material facts that you present must contain all the elements of a legally recognizable cause of action or defense. Now, what does that mean? When you get to court, and now under case management, the judge will already know from reading the minutes of the pretrial conferences exactly what the tribal issue is. It's not like in the past where the judge read rubbish pleadings, which tell him nothing, comes to court, doesn't know what the case is about, and you have to try and explain it in opening statement. Well, that hardly happens anymore. There will be an agreed issue. Your evidence that you present must support that issue, because that issue represents the dispute regarding your cause of action if you're the plaintiff, or your defense if you are the defendant. So the witness testifies. What the witness is doing is presenting the material facts to the judge. They must be relevant to the issue, to an issue. The version itself must come across logically. It must be probable. That is why we say present it in a sequence. Any version that appears to be improbable or contains elements of fact which the judge finds implausible is not persuasive. Now remember, judges don't know whether or not the witness is telling the truth, especially while the judge is listening to the witness testifying. The judge will come to an assessment of the witness at the end, when he or she is preparing judgment. The problem that you have is that if your version amounts to something improbable, it is not persuasive. Now, the judge doesn't have to work out whether the witness told the truth. It's got nothing to do with the truth, because the judge will never know what the truth is. You as a lawyer will never know what the truth is. But as lawyers and judges can work out what probably happened. And how do they work that out? From listening to the undisputed facts and the version presented by the witness. So once you go outside probabilities, you lost the case. Simple as that. Remember to keep the evidence and your submissions relevant to the issues at hand. So relevance is very important. Never present evidence that is not relevant. The judge will become disinterested. Okay. And keep it short. Long-winded presentations don't work. The judge will seek out the agreed facts and the undisputed facts as an anchor or base from which to build a picture of what the judge can safely find is what is likely to have happened. Now, what happens with a judge in a trial is that the judge is faced with conflicting versions, plaintiff's version, defendant's version. What does the judge do? The judge has to resolve that dispute first. It's called resolving a dispute of fact. Now, what judges will do is that they will take or make a note of all the agreed facts and undisputed facts. Now, those things will arise from the pleadings. There'll be a sets of admissions, all of which will be recorded in the minutes, and a good lawyer will tell the judge about the undisputed facts in the opening statement already. Now, the judge will use that as an anchor and then now build a picture of what the judge is thinking of what is likely to have happened. Not the truth, not what truly happened, but what is most likely to have happened. In other words, the judge will test the probabilities of each party's version. And the judge will choose that version which is the most probable. Now, obviously, we know that if a witness performs very badly in court, got taken apart in cross-examination, was shown to be a liar, the judge does not even weigh that evidence in the end. It's just rejected. That is why I'm going to spend some time with you on how to prepare the evidence before you go into court. If your evidence is weak, if your version is improbable, and you have no contemporaneous documentation to support it, you're not helping the judge to come to a conclusion that favors your case. So the bottom line is, the better the quality of evidence, the better the judgment, and the better the reasons for the judgment. Now remember, in our courts, judges can't simply make a finding. They have to give written reasons. Now, making a decision is quite easy, can be easy, but giving written reasons for it is not so easy. And that's what judges have to do. And what's your job? Your job is to help the judge to make that finding. Okay. This is what Lord Bingham said. He's an English law lord, and it's quite telling. Just listen to this. I think that in practice, judges do attach enormous importance to the sheer likelihood or unlikelihood of an event having happened as a witness testifies in deciding whether to accept his account or not. In plain language, what that judge is saying, if the story sounds like nonsense, it is nonsense. If it's not likely to have happened, it's improbable, I'm going to reject it. Now, as a good lawyer, test and retest your client's version, your witness's version for probabilities. If there's any aspect of it that doesn't sound right, in other words, you are thinking it's not likely to have happened, for God's sake, don't present it to a judge. The judge will just reject it. Now, here's a checklist of things you need to know before you go to court. You must know your case concept. In other words, you must know what happened according to your client's version. And remember, you would have pleaded that version. You must understand what the tribal issue is. Now that you would have dealt with before you come to court in case management or in a case conference. And by the way, if you have not done that, please hold a case conference with your opponent and say, listen, we are going to agree on what the tribal issues are. We're going to write it down and we will present it to the judge. That is what you are supposed to do, and please do it. You must know what evidence to lead from which witnesses? Now, I'll take you through that in more detail. You need to know what you want from each witness. Now, remember, when you lead evidence in court, you do so in order to present certain material facts to the judge, which facts will support your cause of action or your defense. Now, before you come to court, you have to do a witness analysis. You have to take each witness and go through the version, go through the statement. Remember, it must be presented in a sequence. And now write down the material facts that you require that are relevant to the issue. You should write that down. And I'll show you a nice technique for doing that. You must know what to ask your opponent's witnesses. You must have a line of attack for cross-examination. And you must also know what not to ask. You know, a really good lawyer will include in his really good technique what not to ask. You know, if you recklessly ask questions in court, if you have no plan and no direction, you simply destroy your case, or you offer your opponent the opportunity to destroy your case. What you will see in this course is I'm going to be showing you how to be in control of your case. Now, I'm very good at giving you checklists because I know they work. Here's a checklist that you need to look at. Is your witness relevant to the issue? Relevance is most important. Never call a witness who is not relevant to an issue. I've seen this happen all the time in court, where a witness is testifying for half an hour, and then the judge looks up and says, tell me, where is this going? Why did you call this witness? What the judge is saying is that I can't see the relevance. The witness must testify in a form that is admissible. So in other words, you don't violate the rules of evidence. The version that each witness presents must be probable when considered in the light of all the circumstances of the case. The judge will want to know that the witness testifies from personal knowledge. The judge will look at reliability. Did my witnesses have enough opportunity to observe what happened and then to give a reliable account to the judge? Can you support your witness with contemporary documents? This is very important. We have discovery. You will know during discovery that there are certain documents that support your witness's version. They are absolutely crucial to your case because judges see documents as an objective, external manifestation of what happened between the parties, and they can rely on it. So use the documents. Do you have supporting evidence? For example, corroboration if it is necessary. You'll need to test if your witness could be mistaken. Is there any possible bias? Now, bias is a dangerous thing. If your witness has a motive to testify, or your witness has is biased in favor of your client, that can undermine your case. So if the witness is biased in any way, I see it's better not to call them. If you simply have to call them, then be careful about how you lead them. Is there a motive to testify? That's bias. It will discredit your witness. Is the witness's version supported by the undisputed facts? That's very important. You test it, okay? if the undisputed facts tell you that your client left a skid mark on the road of 25 meters, and your witness testifies that no, he was driving very slowly. He was doing less than 60, way less than 60. But it's not likely to have happened. It's improbable. The undisputed fact is that there was this enormous skid mark, which suggested emergency braking under speed. And now the witness is saying, he was only doing, must have been doing around 30. Well, doesn't work. You are going to lose the case. Now, there's a preparation checklist I'm going to go through quickly. These lists, you must hold on to them and use them as a tick box. Ultimately, you won't need them because you become good at running a trial. You must have a proof analysis. And what happens there is that you've got the issue. You know what facts you need to present to the judge in order to prove your case. In other words, to support your version in respect of that issue. You have to take each witness, take the statement, work out what is the material fact that you want that witness to present and that it is relevant to the issue. You have to do that analysis with each witness. The proof analysis also includes the probabilities of the version. Where is the witness ranked in order of importance to your case? It's absolutely crucial for you to rank your witnesses. The rule is simple. Always start with the best witness you got. Don't start with your worst witness, because by the time you call your best witness, the damage is done. And never let the judge or your opponent force you into starting just because there's a witness available, but your best witness is not there yet. You ask for an adjournment, you go find your best witness and put that witness in the box first. Always rank the witnesses. Do you have chronology documents for each witness? Now, I told you before, every witness must have two things. You must have two things. One, you must have a statement which was taken down in a chronological sequence, and it must be signed by the witness. That's number one. Number two, you will prepare a chronology document for each witness. This is a document, simple, it just has numbered paragraphs. There's a description and there's a date or time. All you do is you write down the material facts of the version in a sequence, point form, and you have that document in front of you when you lead a witness in chief. It is also a good document to hand to the witness to read together with their statement. And when you call your witness, it works brilliantly if you say to the judge, "My lord, may I hand up a chronology document in respect of this witness to assist your lordship?" Judges love it, okay? It's persuasive. Does your witness have access to the written statement? They must read it before court. It'll be part of your witness preparation. Make sure the witness read it. Are you able to select the documents you will introduce through each witness? In other words, you flag the documents either in a file or you flag them on case lines. There's nothing worse than calling your witness and then saying to the witness, take a look at the document in front of you. And the witness says, "What document?" "Well, the one on page 15. So the witness is paging and then says, "I can't find it." Then the judge will chip in and say, "Well, I don't know what document you're referring to." So it can go horribly wrong. So organize your paper, in other words. Check if each of your witnesses has been through witness briefing. Very important, okay? Make sure every one of your witnesses have been through this briefing. You must have a thorough knowledge of the available facts and where each witness fits into your case concept. You've got a document with the main facts for the witness arranged in a sequence. That's the chronology document. It serves as a reference for you when you are on your feet. It helps the witness tell the story. And you are satisfied that your client's version, your witness's evidence does not fall foul of the rule, and the version must be probable. So let's look at why you lead a witness. The witness must be able to place the undisputed facts on record. It's important because it assists the judge to determine the probabilities. Okay. Now, I'll show you how you deal with this when you lead the witness. You must present evidence that your witness's version of the undisputed facts is probable and can be accepted as true. That's what you want to do when you present every witness. The judge must find the evidence to be clear, interesting, relevant to the issues, and very importantly, likely to have happened. That's what you want. That's what the judge is looking for. You will lead your witness and establish that your witness is reliable and credible. You want to present facts which will enable you to present argument that your client discharged the onus. Now, here's a very important point. I told you, you lead witnesses in order to present evidence of the material facts to the judge, facts which support your case, your cause of action or defense. When you go through the process of leading a witness in chief, you want to bring out those facts. How does those facts help you? Two ways. Firstly, they tell the judge what happened. But secondly, it helps you to make legal submissions in argument. So the witness's evidence must assist you in presenting final argument. I mean, otherwise there's no point, okay? Now, if you lead a witness that will not give you any ammunition in your final argument, well, why the hell did you call that witness? Tell them to stay at home. You want to enhance the likelihood of your client's version. Okay, and I say, remember the balance of probabilities. You mess with that, well, forget it. You are not going to succeed. The judge will expect your witness to lay the foundation for the admission of exhibits. Now, visual evidence is highly persuasive. Judges love it. The judges like to see photographs and maps and diagrams and videos and models and so on. They like that. Your job, when you lead a witness in chief, is to lay a foundation or a basis for the visual evidence. So that, for example, you're leading a neurosurgeon. The neurosurgeon comes to court with a model of the human spine. And now he takes the judge through the anatomy and then explains what happened. It's brilliant. It really works well. And finally, remember this, judges are human beings. They get bored. Your evidence in chief can descend into boredom. It is up to you to ensure that the judge remains interested not only in your witness, but in your story. Now, here's the thing. If your first witness presents a story that is not likely to have happened, or the judge doesn't believe it, well, the judge lost interest right there. So when you call your next witness, the judge is really not interested. In fact, the judge will say to you, listen, Do you think you'll be finished by tea time? You know you blew it when that happens. And I'll show you the technique of how you can actually keep the judge interested in you, in your case, and in your client. Okay, here's the golden rule. You've heard me deal with this before, but I'm telling you, do not make a mistake here. Every witness you call must be relevant to the issue, must be admissible in the form, and must be probable in relation to the circumstances of the case. Never lead a witness who does not satisfy these three requirements. And just remember, you need to get all three. The witness has to be all three, not one of the three or two of the three. It's 3 out of 3, okay? And just remember, it's like those shows on TV. You must get 3 yeses, otherwise you're out, okay? I'm telling you, if your witness doesn't pass these 3 tests, or one of them, even one of them, send the witness away. You are not going to succeed. So now, let's look at questions. Now, when you lead a witness in chief, when you cross-examine, you ask questions. But what to ask and how to frame the questions are not so easy. You must be able to ask the right questions. Being able to ask the right question is central to your performance in court. You know, it really goes wrong in court, and you can see this every day in court. Just go and sit there and watch. The lawyer gets the question wrong, then the answer is wrong, then the lawyer is scrambling to try and fix it. Or the lawyer asks the question and the witness doesn't answer it, and out comes a wrong answer. Okay, there are so many things that can go wrong if you don't frame your question correctly. It determines how you bring out the relevant evidence and how comfortably your witness performs. Now, you know, if your witness is confused by the way you ask questions, well, I'm telling you, you're going to lose the case. A confused witness is the worst kind of witness you can have. Use the right questions in the correct way. Your witness will be more comfortable. They'll understand you. They'll settle down in the witness box. They'll be good witnesses. And I can't resist giving you pointing this out. You know, Albert Einstein was asked to define a good question. What is a good question? He was asked. I read this in his one of his autobiographies. The question was, what is a good question? And his answer, brilliant. He said, a good question is one that is understood and it has an answer. Now, when you ask a witness a question in chief, the witness must understand it and there must be an answer. And you must know the answer. Lawyer always knows the answer, okay? I mean, you get questions that nobody can understand. For instance, if my wife is dressing up for her cousin's wedding, you know those boring things that you get forced to go to. She puts on an outfit and she comes to me and says, do I look fat in this dress? Now, that's not a good question. Because firstly, I don't understand it. And secondly, it doesn't have an answer. Because if I say, oh no, you don't look fat in this dress, she'll say, you're a bloody liar. Well, if I say, oh yeah, you do look fat in that dress, then I'm an insensitive swine. You see, there is no answer. Okay. Now, as a lawyer, you only ask a question which is understood and there is an answer, okay? A clear answer. Never ask a question that might confuse your witness, even under cross-examination. You never ask a question you don't know the answer. Now, on your feet, here's some practical guidance. When you ask a question, whether it's in chief or cross-examination, the witness must effortlessly understand it. Easy peasy. The witness must know what you want. You achieve this by firstly, of course, preparing the witness, but in court, use clear language, plain language, no big words, no over-the-top drama. The witness must understand. You know, how often do you find witnesses in court saying, could you repeat that question? I'm not sure, I didn't hear that. Can you repeat it? You know, very often it's not because they didn't hear, it's because they didn't understand the question. So they're asking you to repeat it. But witnesses won't say, I don't understand that question. They'll say, I can't hear it. Or I'm not sure what you said. Can you repeat the question? That is terrible. It looks very bad. Because what happens is your witness now starts creating the impression that they're being evasive about something. Well, your opponent will certainly take it as evasiveness and will try and nail you in cross-examination. Now, so it's very common in court for a witness to ask you to repeat. It's usually the fault of the lawyer. Two things went wrong. The manner in which the question was framed, so they didn't understand it, or sometimes the lawyers are not audible. They didn't hear it. Okay. Always use the technique of one question, one fact. Do not ask a question that has multiple responses in it. That confuses a witness. When you get the evidence you want, in other words, the witness answers the question, move on to the next question. Don't dwell on it. Avoid repeating questions to elicit the same evidence in order to emphasize a point. Please don't do that. I know judges, I mean, many practitioners do it. The witness gave what the practitioner thinks is really one of his best points, what we call our bullet points. The judge heard it. Don't ask again to repeat it. That's the judges get fed up with that. They'll tell you asked and answered, and you end up looking like a fool. I told you your question must have an answer. So how do you know? Because you know the answer. Good lawyer never asks a question they don't know the answer to. Okay? Because, as I'll show you, a good technique in leading a witness in chief is first to think of the answer you want and then ask the question to bring it out. You don't think question, you think answer. That's a good lawyer. You have your witness analysis. Now you bring out the facts you need for your argument. Now, that is the key. What you want to do is bring out the facts in a manner that is interesting, makes sense, so that you can use those facts in your final argument. That's the whole purpose. So now let's get on to the leading question. Now, we all know that in chief, you are not to ask leading questions. A leading question is one that suggests the answer. You know that the judge wants to hear testimony from your witness, from your witness's personal knowledge. What the judge doesn't want to hear is the lawyer giving evidence. And I've seen this in court so often, where the witness is standing there in chief and saying yes, no, yes, no. And who's giving the evidence? The lawyer is giving the evidence. I promise you, when the judge weighs the evidence, the judge will find that you gave the evidence and will promptly say that it is of no probative value and completely reject the evidence. Now let's look at the rule. When dealing with disputed fact or a disputed version, you are not to use leading questions. If you do, you will undermine the witness's credibility and you will look like an ass, okay? Judges will know when you cross the line. They will know that you suggested an answer to a disputed fact. What you did is that you destroyed the weight or value of that evidence as proof of a fact. You can't do that, okay? But there is nothing wrong with using leading questions to bring out facts that are not in dispute. That's perfectly allowed, and I'll show you how you do it, but never take it for granted. You know, things like the formal things that are not in dispute, like the person's address and place of employment and so on, they're not issues in the trial. Or the fact that they were driving a red car on that day, it's not an issue. You can lead. But if you do ask leading questions to bring out the undisputed facts, because it saves time and it's easy, always tell your opponent. Go tell your opponent, listen, I intend to lead on these undisputed facts. Do you have any objection? And the opponent will say, no, not a problem. So when you're in court, you will tell the judge, my lord, I'm going to be leading my witness on certain undisputed facts. My learned friend has no objection. And then you ask the leading question. You say, Mr. Mokoena, you live in Attridgeville and you work at Checkers. Leading question. That is not in dispute, so it's not a problem, okay? Leading questions are, of course, effortless to answer, but they are seriously damaging in the wrong hands. When you ask leading questions in a disputed fact, you can expect your opponent to object, and the judge will sustain the objection. Now, here's the problem. When your opponent successfully and repeatedly sustains objections against your leading, you have just destroyed your own evidence. It undermines you completely. Now, the problem with this is that it's not the witness's fault. The witness may genuinely be able to tell the judge what happened, but you made the mistake of asking leading questions. It just undermined the whole thing, and you will pay a price in final argument. Okay, now this is difficult for you to see, but you're all familiar with what are open questions. We have open questions and closed questions. I'll deal with closed in a minute. Open questions, in one of the problems you have is to avoid the leading question. And this is a useful technique. When you begin your question with these words, who, what, why, when, where, how, describe. Those are open questions, okay? Who did you notice on the scene? Okay. What happened when the defendant arrived? Why did you sign that document? Those are open questions. They are not leading questions. They are used to bring out evidence in respect of disputed facts. And they're not leading questions, easy to understand and follow. But remember, even open questions can get confusing if you don't structure them correctly. Simple question, one fact at a time. The witness must understand it, and there is an answer. and you must know the answer. Now, closed questions is also another form of non-leading question. This type is used when you seek a specific answer from a witness. So you want to confine the witness to a specific response. It's not like describe what you saw or tell his lordship what happened when the police arrived. Those are open questions. Closed question, you want one answer. What time did you get to work? Okay. Take a look at this document. Whose signature is that? Okay. So you want to confine the witness to a particular answer. You are limiting the witness's choice of answer, but the question is not leading. There must nevertheless be a choice of answer. So when you say, whose signature is that? The witness has a choice. The witness can say, that's Mr. Smith's signature, or it is not Mr. Smith's signature. So there's a choice. But if you say, take a look at that document, is that Mr. Smith's signature? That's a leading question. Okay. So it depends on how you phrase it. Now, here's an important part. Voice intonation also plays a part. Now, let me give you an example. What time did you get to work? Closed question, but there's a choice of answer. The witness can say, I got there at 7 in the morning, or I got there at 8 o'clock. Okay. But if you say, Mr. Smith, you arrived at work at 7 in the morning. That's a leading question. Now, how about this one? Did you arrive at work at 6 o'clock or 7 o'clock in the morning? Now what? The witness has a choice. The witness is limited to 6 or 7. That is not, strictly speaking, a leading question. But the same question with vocal emphasis on 7, it will sound like this. Mr. Smith, did you arrive at work at 6 or 7? So you are suggesting with voice intonation that the answer you want is 7 o'clock. Now you are crossing the line. That will be a leading question. Let's look at another example. The question is, the man you saw that evening, was he tall or short or of average height? So you gave the witness choices. That's not a leading question. And the judge will wait for a response. No problem. But if you say, was the man you saw tall? That's a leading question. Okay. Now you have given the witness a choice between yes or no. Was the man tall? Yes or no. You are asking a leading question. It may depend on how you develop the evidence. Now, but what if you inadvertently place the emphasis on the word tall? Was the man short or tall? Well, the witness is quite clearly being told the answer is tall. Now, this kind of evidence happens in cases involving identification. It's very important. Look, all of us as lawyers, you will come across a case where you'll deal with identification. The way to avoid the problem is to lay a foundation through the use of open questions. Then use the closed question to bring specific facts. So I'll give you some examples of this later. Now, the effective use of questions. It's very important. You must carry out witness briefing before the witness is called to the box. I told you that. Never underestimate this. A calmer witness will hear you better, will understand your questions, and respond better. A nervous witness who can give you the best version. If that witness is anxious, not settled, worried about what's going to happen, is unsettled, suddenly they don't understand your question. You know, you often hear lawyers, this is an old lament of lawyers. They lose the case and you'll hear the lawyer saying to his colleague or to the client, oh, we were dropped by the witness, or the witness dropped me. Well, I can tell you, you never hear a lawyer say that when they win a case. You'll only hear them say that when they lose a case. And it's mainly because the problem is with the lawyer, not the witness. Okay. Now, here are some things you can do to help your performance. Now, yes, firstly, let's look at what you shouldn't do. Do not write your questions down on a piece of paper or have it on your laptop, a list of questions, and ask the questions from there. That's no good because it damages your performance. If you stand there with a piece of paper in front of you, you're blocking your face. You're now no longer maintaining eye contact with the witness and with the judge. Your eye contact is with the paper. Very bad technique. Okay. You are, by your own actions, no longer addressing the judge. You're addressing a piece of paper. That stupid list of yours will be a distraction and it undermines your performance. Now remember, this is advocacy, trial advocacy. You're there to persuade. You don't want to read a question from a piece of paper. You must confidently be able to ask the witness a question and the next question and the next question without reading from a piece of paper. But I'll tell you what will help you. A chronology document. You should have a chronology document in front of you. It will be a good idea to prepare that chronology document in big font so that you can keep it on the desk and you can easily reference it without losing eye contact with the judge and the witness. That the reason people want to look at a list is because they're concerned that they'll forget about a question or they may overlook something. Of course, that can happen. But you don't want to read out questions from a list. But if you have a chronology document in front of you, that helps. And remember, the judge will have one too. Good preparation will give you confidence to lead your witness without having to hang on to a list of questions. Preparation is all about confidence. And here's the chronology document. It must be one page, okay? And don't hold it in your hands, put it in front of you, big font. Now, what's the best technique? The best technique is first think of the answer you want. Now you're leading your witness in chief. You want a certain answer. You want certain evidence to come out. So you will ask the question based on the answer you want. Don't merely ask questions and hope the right answer comes out. That's a bad lawyer, and I see it all the time. Okay? You want to bring out the answer using a simple, short, non-leading question. After you introduced and qualified the witness, then start leading the witness on the relevant version. But let the witness do the talking. You simply guide the witness, keep the witness relevant and to the point. Control, in other words. Now, here's some suggestions. Have the chronology document in front of you. Lead your witness always. Always lead witnesses in a sequence from the start, step by step to the end. That's the way judges want to hear evidence, sequentially. That document will also provide your witness with a guide. The witness settles down and it is easy to concentrate. And trust me, lawyers and witnesses have a habit of taking leaps backwards and forwards in time. In other words, they're not in the habit of presenting sequentially. In fact, they're in the habit of doing the opposite. It's confusing to the witness, it's confusing to the judge. Prepare and have chronology documents. When you prepare for trial, give the witness the chronology document. Tell the witness you will lead the evidence according to that sequence, the sequence of events as you see it. Tell your witness to use the chronology document to refresh their memories. But the witness, of course, must be familiar with their statement. Now, you see, they read the statement, which may be a long statement, but the chronology document serves as a refresher. In a sequence, it tells them what happened. You must have a list of your witnesses in the order in which you want to call them. You will know who your next witness is, and they must be waiting outside. It's very slick and professional. When the judge says, yes, Mr. Smith, the judge is merely saying, are you calling a witness or are you closing? When the judge does that, you must be able to say, my lord, I call my next witness. It's Mr. Jones. He's waiting to testify. And Mr. Jones then walks in very nicely. Not this business of, would your lordship bear with me? And then you whisper with your opponent, with your attorney here and with your clerk there. And then you say, oh, my lord, would your lordship allow me a short adjournment? I mean, judges get so irritated with this, you don't believe it. So if you are going to close, then you stand up and say, my lord, that's the evidence. Sit down. Okay. Oh, and now here's another practical thing. Always check if the interpreter is available and present before you tell the registrar to call the judge. Because, gosh, it's so irritating. Everything is set. You want to start. Your witness is in the box. And guess what? The interpreter is missing. You know, it's so irritating. And the judge will blame you for it. See that the bundle of documents and exhibits are available in the witness stand for access by the witness. Ultimately, we will have a monitor in the witness stand, and the witness will have access to electronically filed documents. But we're not there yet. Okay. Can you imagine when we get monitors for everyone? Then instead of looking for the interpreter, you'll have to first check if the system is working. Because, you know, it's our justice department. The system won't be working most days. Then we'll end up back with bundles. I really hope that doesn't happen. Your documents must be in order before you begin. So you know you're calling your first witness, Mr. Smith. You must have the documentation relevant to that evidence, okay? Marked or pulled out of a bundle, easy access to the judge for the witness. There must be no time wasting where you shuffle paper and you say, would your lordship just bear with me? And you're looking for a document. I mean, that looks stupid, okay? You must be organized. Do not irritate the judge by standing there and repeatedly saying, would your lordship bear with me? You look like a fool. But, you know, we will have electronically filed documents. They will be easier to manage. Case lines is where we're heading. Okay. Now, I'm also going to talk to you about voice, obviously. You have to be audible. And remember, courtrooms have poor acoustics. They're not great. Some of the smaller courts in Johannesburg, the acoustics are fine, shouldn't have a problem. But if you're appearing on in any of the courts on the ground floor in Johannesburg or Pretoria or any of the magistrates' courts, they are noisy. Okay, I don't know why this happens, but just as you lead your witness, somebody switches on a leaf blower. Those confounded things. Someone is blowing leaves from one end of the passage to the other. And I mean, it makes such a racket. And then as soon as they stop, then a cop car goes by with a siren blaring. It's just, you have to manage it, okay? You need a good, strong voice that can be heard without you having to sound like you're shouting at the witness. If your voice does not project well in court, then please go and get help. We now have technology, we have therapists, speech therapists that can help you to correct your voice and make you more audible. Because remember, if you can't be heard, you can't be persuasive. Simple as that, okay? If you are going to a court that you're not familiar with, then go and check the acoustics. If you are in another province or a court you're not familiar with, check with your colleagues. Ask the local guys what are the acoustics like in that court. I mean, the Pretoria, the Palace of Justice, those of you who've been there, I mean, they're magnificent courts. On the ground floor, courts A, B, C, D, and E. The acoustics are atrocious. They're very old buildings. The judge sits on a very high elevated spot, far from where you are standing, far from the witness box, and it's very difficult to manage. And also, confidence has a lot to do with how you project your voice. If you are well prepared, you are confident, you sound better. But if you didn't prepare well, you're not sure what you're doing, your voice suddenly just lets you down. You want to strike a balance between politely audible and being aggressively loud, okay? You don't want to be shouting. Whatever your style, you must sound like you are being polite and respectful of the judge and the witnesses. You want to be perfectly audible. That's the professional way, okay? Use plain language. And the weirdest thing is that when you are easily understood, suddenly everyone can hear you. It's remarkable, okay? But if you use big words and bombastic language, you're verbose, well, guess what? Suddenly the witness will say, I didn't quite hear you. Could you repeat that, please? Okay? So don't use plain language. Now, when you speak, it is important to actually direct your voice, okay? Speak in the direction of the person you are addressing, and this will be the witness or the judge. Maintain eye contact with the witness. When you ask the question, when the witness answers, eye contact with the judge. That's how it works, okay? That way, the judge feels engaged, the judge feels included. You know, I've seen this happen so often where the lawyer and the witness strike up a lovely conversation and they getting along brilliantly and they're enjoying themselves. And the judge is sitting there wondering, you know, do these people realize that I'm here? Hello, I'm here. Don't do that. Involve the judge. If the judge is not listening to you, well, you're not being persuasive. So you want a clear voice, short questions, plain language. It works, okay? That's what works. You must be interesting. Now, you know, you may have seen television programs of courtroom dramas. And it's all very dramatic. And the lawyers look like they're the real stars. They are so brilliant. Well, trust me, it doesn't work like that in real life. But that doesn't mean that you must be boring. Don't use a disinterested monotone. Now, there are people whose natural voice is a boring monotone. They don't intend to be boring, but they just sound boring normally. If you're one of those people, go and get speech therapy or read a book on speech, on voice articulation. You can fix it, okay? It's a performance skill. If you look like you're not interested in this witness, so you ask a question and then you're busy looking at your papers, or you have a chat with your colleague sitting next to you, and the witness is talking. The judge can see you're not interested. So the judge is thinking, well, why the hell should I care? You're not interested, why should I care? So you must expect the judge to be interested in your witness. And a lot depends on how you perform. So don't use a monotone. When you ask questions, make it sound like something the witness and the judge will be interested in. When the witness answers, pay attention to the answer. Hang on to their every word. Keep eye contact with the judge. Your enthusiasm will encourage the witness, and the evidence will become more persuasive. While the witness is talking, avoid starting to write and lose eye contact. This becomes a distraction. No, you want to make points and so on. But you know what? There's a way to cure this. Good lawyer, good trial lawyer prepares draft heads before they come to court. So you got draft heads on your computer. When you finish with a witness, during a break or an adjournment, you fill in the main points that came out of the witness into your draft heads. You don't have to sit and make notes while the witness is testifying. That's a complete distraction, and you lose eye contact with the judge. It is important for you to see if the judge is following the evidence, because you have to pace yourself. Now you get two kinds of judges. There are judges who prefer to write down the evidence in chief. As the witness is testifying, they're writing. And trust me, they write down all the evidence. I mean, they're like stenographers. I mean, they write it all down. If you're before one of those judges, then pace the witness according to the judge. Don't outstrip the judge. They'll get irritated. They'll tell you, slow down, or I have to write this. You're going too fast. That's no good, okay? The other kind of judge sits and listens and will occasionally write a note, okay? So make an assessment of what the judge is doing and perform accordingly. You never race ahead of the judge. If the judge is going to remind you all the time, it doesn't work. Listen to the answers your client is giving. Now, here's the trick. Instead of writing notes all the time, your job is to listen to the answer and remember the details for your argument. Now, remember, you already knew what your witness was going to say. You already drafted heads where you've put that into your heads already. So there shouldn't be a need for you to feel that you must write everything down, okay? Now, the other reason why you want to listen to the answer is because you can't control your witness. Because if the answer is something you are not expecting, you have to deal with it in a certain way. And I'm going to show you how. But now let's go to the types of questions again. What I'm going to do now is a very important technique. I want you to concentrate and listen, because I'm now going to show you how you can lead a witness and avoid using a leading question. Now, you may have seen this in court. It happens all the time. Lawyers leading a witness in chief asks a question, doesn't get the answer he wants. Okay, asks another question, sort of rephrases, still doesn't get the answer he wants. Then asks this another question, a third question, trying to get the same answer, still doesn't get the answer. So what does the lawyer do? He says, well, bugger it, I'm going to ask a leading question, and ask the leading question and hopes he gets away with it. Well, you never get away with it, okay? So ask short questions which must be understood in only one way. Once you ask long questions, it becomes subject to interpretation by the witness, and they will get it wrong. It must sound like you are holding a conversation with your witness, okay? Do not ask multiples of questions in one go. Where were you on that day? What were you doing? And what happened? You lose control. Now, take a look at these questions. Where do you live? Where do you work? What is your job description? One question, one answer, simple. They are open questions, and it's good technique. Look at this, same question. Mr. Smith, tell the court where you live, where you work, and what is your job description? So, what do you have here? Same questions, but you fired all three questions off in one go. That's no good. You must stop it. The witness might remember one of the three, and the witness might answer, I am the financial manager of the company. And he's forgotten about the other questions. So that's no good. Your witnesses may be nervous in the witness box. When you stand up and ask multiple answer questions, it's not fair to the witness. The witness is now put under pressure to answer from a list that you gave them. I mean, that's not on. Don't do it to them. Because most witnesses will give you a response to one of the three questions, okay? You could then leave out an important piece of evidence, and your witness's credibility could become a problem. You can just hear your opponent will say, my lord, Mr. Smith refused to answer that question. He didn't refuse to answer it. He forgot to answer it because he was confused by you, okay? Now, it is a good technique to use short questions eliciting a particular answer. But remember, the judge is keen to hear your witness's version. A series of short questions might not bring out the narrative the judge is looking for. So the judge wants to hear a story, but most importantly, he wants to hear the story from the witness, not from you. Do the following when you come to the disputed facts. When the witness starts telling the judge the witness's version of the disputed fact, that's when the judge starts leaning forward and concentrates, because now this is what the judge needs to resolve the dispute. The judge wants to hear the version. Allow the witness to tell the version. Allow the witness to explain what happened. Don't interrupt. Let the story flow. I'll give you a technique of how you can control this. Interrupt only when the witness drifts off the topic and you have to bring them back to being relevant. When you have what you want, in other words, you got the material facts that you need from this witness. How do you know that? from your witness analysis. Your witness analysis told you this is what you want. Good lawyer will also have the chronology document, and on the chronology document, you will either highlight or you will mark off the material facts that you want. So you've got a list there. You ticked off that list. You got what you want. Sit down. But you must do it confidently. And I say, without looking smug, just be confident. My lord, that's the evidence in chief, and sit down. Don't do this. Don't say, Mr. Smith, is there anything else that you'd like to tell his lordship? My God, what a stupid question. Why? Because it's not a good question. You don't know the answer to that question. You should never ask it. I've seen that happen, where the lawyer got what he wanted, but he still now, to close off, says, is there anything else? Well, you might have a talkative witness and might say, yes, there is something else. And out will come something you were never anticipating, and it damages your case. You got what you want, sit down. Now, let's look at how you avoid the leading question. This is important technique. There is a method that you can use so that you don't have to ask the leading question. You know, when you get stuck for an answer, you somehow can't get the witness to give you the answer you want. That's when you'll decide, I'll ask the leading question, and you damage your whole case. Now, there are certain techniques that you have to use. The one technique is what we call the headline method. It's very useful. It's also known as signposting. What you do is, before you ask your short leading questions, tell the witness where you are going or what you are dealing with. So, you want to ask a series of questions about the witness's employment. So, before you say, where do you work? What is your job description? How long have you been working there? What was your position on such and such a date? What did you see? Okay. Before you do that, you give the witness a headline or a signpost. You will say, Mr. Jones, I am going to ask you about your employment. Right. Now, two things happen. One, the witness now knows where you're going and will immediately connect with your questions. Very important, the judge knows where this is going. The judge now knows that, well, I'm going to hear about the employment. The judge would have worked out what the relevance is. Now then follows short questions to bring out the details of the employment. Mr. Smith, here's an example. I'm going to ask you about an incident which happened in Vilagazi Street. Now the witness knows what you want. The witness is not going to speculate, and they prepare themselves in their minds to answer questions about an incident that took place. Then you will get the witness to explain what happened in the street. You will say, for example, Mr. Maseko, I'm going to ask you about a document you will find on page 55 of the bundle in front of you. Now, go to the document. Yes, I have it. Now you bring out the evidence. Get him to identify the documents and the details that you want. So this is why the method works. These are the advantages. Firstly, it helps you to arrange your examination in separate topics. Now, by now, those of you who are up to speed would have realized that the best thing to do is to use your chronology document as headings. Okay? You get your headings from your chronology document. Your document tells you each incident that took place. You use that as a heading. Mr. Jones, I'm going to ask you about a signature on that document. Right, now Jones knows what to look for. He opens the document, and then you will see. Then you lead the Jones. What do you see at the bottom of that page? I see a signature. Whose signature is that? It is Mr. Shabalala's signature. You see, so there's no confusion. The witness knows, and you guided the witness. It prepares the witness to answer questions. It avoids confusion. It helps you to avoid using leading questions. You see, when the witness knows what you want, you won't have to extract it out of them. It won't be like squeezing an answer out of them. It comes out effortlessly. And very important, the judge knows what to do. So that is why we say you're giving the witness a headline or a signpost, okay? Here's a practical suggestion. I pointed it out already. Write your headlines into the chronology document that's sitting in front of you. It makes it so much easier. You will lead your witness systematically. There'll be no confusion, and it works very well. That's the one technique. That's the signposting technique. But there's another technique. It's called the looping back method or the piggybacking method. Now, these two techniques work hand in hand. So first you give a signpost, and now when you ask questions, you ask your next question based on the answer to the previous question. So you say, Mr. Smith, where do you work? I work in Standard Bank. What work do you do in Standard Bank? I work as a credit controller. What entails your job as a credit controller? I control the credit levels of our clients, and I decide who is entitled to further facilities, and so on. He gives an answer, okay? The defendant, what do you know about the defendant? He's a client of the bank. So you see, what you do there is that your next question is based on the answer to the previous question. So if he says, I work at Standard Bank, I say, what work do you do at Standard Bank? You see, it's not a leading question because he already said he works at Standard Bank. Now I'm going to say to him, what work do you do at Standard Bank? I work as a credit controller. What does it entail to be a credit controller? So you're piggybacking on the answer to the previous question. That way, you will not fall foul of leading. So technique number one, give a signpost. Technique number two, build your next question from answers to the previous question. Can't go wrong, okay? Here's an example. I'll go through this quickly. The witness says, I work at, Jones is the lawyer. He says, where do you work? I work at Checkers. What work do you do at Checkers? I'm a floor manager. For how long have you worked as a floor manager? 10 years. During your 10 years, how often did you take sick leave? I only took sick leave twice. On both occasions, did you provide a medical certificate? Yes. To whom did you present this medical certificate? To the human resources manager. Who is the HR manager? Mr. John Ruiz. Do you see? Each of those questions came from the answer to the previous question. It works nice and smoothly. And you will see there are no leading questions. That's what you want to do. So it's simple enough. And this is simple enough and represent a set of facts that's not likely to be disputed. So, you know, when you're leading a witness in chief on undisputed facts, that's very easy. Now, what happens when you are dealing with disputes? Look at this. Mr. Smith, I'm going to ask you about an incident that took place on the 14th of July, 2020. Right. Now, headline, signpost. You told Smith, this is what I'm going to ask you about. Now you go. Where were you on that date? I was driving my car on Main Street. Where in Main Street, where is Main Street located? It is in the CBD of Benoni. Okay, now I gave you your materials. If you look at page 17, there's a whole case study there on how you use the technique of looping or piggybacking on the answer to the previous question. The evidence is given without the lawyer having to ask leading questions. You'll also see that we used the signposting method each time. Okay. Now let's look at a closed question. I'll give you a break in a moment. Okay, a comfort break. I just want to finish this. Go back to the closed question. You can easily fall into the trap of asking a leading question. The best technique is to lay a foundation for your questions by beginning with a series of open questions. Okay, so here's an example. Smith, the lawyer, says, you saw the defendant attempting to get out of his car. Yes. When you observed him getting out of the car, what caught your attention? Do you see? That question is based on the answer to the previous question. The witness says, he was fumbling with the door and struggled to exit the vehicle. When he was struggling to get out of the vehicle, was he injured? No, he was not injured. What was his condition? Was he sober or drunk? He was drunk. Now, what was his condition? Was he sober or drunk? That's an open question, not a leading question. But if I said, what was his condition? Was he sober or drunk? Now you cross the line. Okay. But what you did is that you laid a basis that there's something wrong with the defendant. Okay, he's fumbling, he's all of that stuff. And then you say, what was his condition? Okay, sober or drunk. And now you laid a basis that's now acceptable. But if you laid the emphasis on drunk, you would have crossed the line. Okay. Okay, let me just finish this. This is a big problem with practitioners. Repeating the answer, it's a problem. Mostly lawyers repeat the answer to buy some time while they work out where to go next. This is a lawyer that's not organized. If you repeatedly repeat the answer, a judge will stop you. But most importantly, you know that repeating the answer irritates judges. It wastes time and makes you look like an ass. But it creates the impression that you are trying to overemphasize the point. But overemphasizing is one thing, but you may be on the wrong point. Avoid random or idle repetition, okay? It doesn't work. All right, here's a good example. If you have to repeat an answer, this is how you do it, okay? Now, you want to present evidence that the witness was drunk. So you asked Mr. Smith, what was his condition? And he said, the witness says, I noticed he appeared to be drunk. That's the answer. This is what a lawyer will do. He was drunk, and at the same time, Smith pauses, lets it sink in, and looks at the witness. And when the witness says he was drunk, Smith then looks at the judge with a meaningful stare. Okay? That's the bullet point. You want to prove the defendant was drunk. The witness says he was, and you go, He was drunk. So you're not going to let that slide past. Now that's good advocacy, okay? It works, but reserve it for your main point only. Never overdo it. Otherwise you look like you're on TV and then you start looking like a drama queen, okay? Or you look like you're playing to the gallery. You never play to the gallery, you play to the judge, okay? All right, I'll deal with this. Let's take 10 minutes, please, not more. Let's get back at 5 to 1, okay? 5 to 1 sharp. I'll start. Right. Okay, let's get started. Betty, am I sounding okay? Is the technical stuff still working?
It's working, Judge, but I can't see you. There's
Oh,
no visuals of you.
I think that may be a problem now.
No.
There's maybe some, is everyone having the same problem? Now the others can see me. Yeah, it's your computer, Betty.
Then it's my computer. Let me take a
Yeah,
look at it. Let me take a look at it.
yeah. You've got a law society computer. Okay, let's carry on. Now, remember this. Whatever you do in court amounts to communicating with the judge. That's what you're doing. When you make, from the point when you make an opening statement through the evidence, right down to final argument, you are constantly communicating with the judge. When you lead a witness in chief, you are communicating the evidence to the judge. So your whole performance is a communication skill. Now let's look at some suggestions that will help you. Firstly, we know that you have to be audible. The judge must hear you. When you lead your witness, involve the judge. It's so easy, as I told you, to become involved in a nice conversation with your witness and you forgot the judge. You can avoid this by making eye contact with the judge, especially when an important piece of evidence comes out. Here's an example. Smith, now the lawyer, instead of asking, what did you observe about the defendant? Now, you know, this is an important fact coming out. So instead you will say, Mr. Smith, tell his lordship what you observed about the defendant. Okay. Or you can say, I'm certain that his lordship is interested in what happened to the defendant when the police arrived. And at that time, you make eye contact with the judge. So you're bringing the judge into the conversation all the time. So instead of saying, what did you notice about the defendant or what happened when the police arrived? These are crucial moments in the evidence. You will say, tell his lordship what you saw. I'm sure his lordship wants to hear this. Okay. Pacing the evidence according to the judge is very important. Observe the judge. See if the judge is interested and listening. Rumor has it that judges sometimes stop listening. When the judge interrupts you, say at 10:30, and says, Mr. Smith, do you think you'll be finished with this witness by tea time? Oh boy, you know you went wrong somewhere. The judge lost interest. When you're leading the witness, keep eye contact with the witness and the judge. Don't maintain eye contact with the interpreter. And definitely leave the gallery alone. You know, the interpreter is, I've written a whole chapter on interpreters in my book, but they are so important. But it's also important to know that the interpreter is an interpreter. The interpreter is not the witness and is not the judge. So don't find yourself engaging into a conversation with the interpreter. You should be addressing the witness and the judge. Okay. And for God's sake, don't lead your witness in a sleep-inducing monotone. You must appear to be interested in your witness. Now, you know, not everything we do in court is interesting. A lot of the stuff is really boring. But you can look like you're interested. A lot of what you do in court, the communication skills, involves a bit of acting. You must learn to look interested, okay? Don't be boring. Okay, now I'm going to go through a list very quickly with you. What this is are helpful tips that I've dealt with already, but I wrote them in a way that will give you a reminder and help you to be better courtroom lawyers. Do not ask leading questions, okay? Nor should you assume facts are in evidence before there's testimony from a witness. So we've dealt with this. Asking leading questions in respect of disputed facts is taboo. Don't do it. The technique is you must think of the answer. You must know the answer. If you prepared your witness well, you will be confident to elicit the details you want. Then you ask a question where then you can ask a question where you do not know the answer, but be aware of the situation where there are a number of issues not addressed in the statement. So my suggestion is stay away from those questions where you're not sure what the answer is. You must carry out a witness analysis, okay? Use a chronology. Now, setting the scene, this is an important technique. And lawyers fail on this so often. Remember, a judge is hearing the story for the first time. They don't know anything about the case. They walked into court. They may have read the pleadings and the pre-trial minutes. That's all they know about the case. The witness's version, they're hearing for the first time. So what you do is you set the scene first before you get to the material facts that you want. For example, let's say the dispute is negligent driving in an accident case. So you call your first witness to testify about the way the defendant drove the car. Now, that's very important evidence for you. Don't start with Mr. Jones, where were you on such and such a date? I was driving in Main Street. While you were driving in Main Street, tell the court what happened. So now the witness starts telling the judge that he was driving down Main Street, and as he approached the robot with Thabo Mbeki Drive, the defendant came from the left-hand side. And as he was driving from the left-hand side, I noticed that he was speeding and he didn't stop at the robot. He then carried on down Thabo Mbeki Road, but before he could cross the intersection, he smashed into another car. Now, you see what happens. The judge is thinking now, what does down Main Street mean? What is left of down? So the judge doesn't really know what the scene is like. Now, that's a bad lawyer. Wherever you lead a witness and it involves an event or a scene or a building that collapsed or a bridge that collapsed, first set the scene. You can start with a headline. Mr. Jones, it's common cause that you were involved in an accident on such and such a date. I'm going to take you to the scene of the accident. Take a look at this document. That is a diagram of the scene. Now I'm going to take you through it. Okay, where is Main Street? In what direction does it run? Where is Thabo Mbeki Avenue? In what direction does that run? Are there markings on the road? Is the intersection controlled? Does it has robots? Can you point out the robots? So what you're doing is you set the scene. So now when you start talking about the accident, when you lead the witness about what actually happened, the judge gets the picture. The judge will have a map in front of him or her, These days, we have the benefit of Google Maps. You could have a perfectly good aerial shot of just about anywhere on the planet. You must use it. In the past, aerial photography was unheard of. Well, you could do it, but it meant you hiring a helicopter and a professional photographer, and the cost of taking one photograph will exceed the costs of the whole trial. So we didn't do it. Now you can. You could do it on your own. You could go with a drone and take pictures. So I think you would have missed an opportunity if you did not set the scene first by using visual evidence. I keep telling you, never lose an opportunity to use visual evidence, maps, photographs, diagrams, videos. Judges just love it. Always use plain language, okay? I mean, look at this question. Mr. Jones, will you please elaborate by telling his lordship precisely what color was the car when you saw it enter the intersection? I mean, your witness will be confused. You could easily have said, Mr. Jones, what was the color of the car? Simple, okay? You don't have to sound important. Let the witness tell the judge what happened. Let the narrative come from the witness. Only interrupt when they become irrelevant. Now, look at the technique we're going to use. If you use a chronological sequence, you lead the witness by saying, here's the headline. This is what I'm going to ask you. Then you build your questions from the answers to the previous question. What you're doing now is that you're actually controlling the witness, because now the witness is not left to go on and work out what to testify next, in what order the evidence must come out. You'll be controlling it. You'll say, now, Mr. Jones, let me ask you about the credit rating of the defendant. And now we're going to talk about that. So the story comes out, you maintain relevance, and you control the witness, okay? So for example, Jones, your witness, left out something important. So you'll say, Mr. Jones, let me stop you there for a moment and take you back to the intersection after the police arrived. Okay, you see what you did there is he left something important out at the intersection after the police arrived. So he's given the evidence about the incident. It took place in the intersection and that the police arrived, but he left out something. You did two things. You're telling him where we're going. So you gave the headline. Okay, you gave him the signpost. Now he knows that, hold on, I must have forgotten something. And this comes out then. Okay. Allow the story to flow instead of merely having the witness give one-word answers to a series of short questions. When you do that, you invariably end up asking leading questions. You must go from one scene change to another, one part of the episode to another. And who does that? You do that. And how do you do it? By using the headline method. You give a signpost or a headline. I'm going to ask you about, or Mr. Jones, we are going to move to another scene. I'm now going to ask about the following. The witness follows you, the judge follows you, and it works very well. I'm going to say no more about chronology. We don't want any haphazard accounts of what happened. Judges hate it. You want a sequence. It is a very good habit for you to listen to your witness. Focus. Otherwise, you will miss the opportunity to ask a follow-up question. There must be eye contact, okay? pace yourself, keep the story interesting, okay? So you have to work to hold the judge's attention. Now remember, judges are hearing cases all the time. They're human beings. They've heard all this nonsense before, you know? But you want the judge to be interested in your nonsense. He must be persuaded by your story, okay? When you come in where your witness comes to a material conclusion or material set of facts, never let the moment pass, okay? And move on. It's like the example. It is a material fact of one of your material facts that the other driver was drunk. And here's a witness, a police officer who says the driver was drunk. You will say, after a pause, officer, what did you conclude from the defendant's behavior? And now look at the judge. He was drunk, my lord. And you've got this telling expression on your face, okay? Always vary the type of questions you ask. Combine open and closed questions and transitions. It'll help you to stop sounding one-dimensional. It makes you more interesting. Always bear your analysis in mind. I've dealt with analysis over and again. It's part of your preparation. Bad habits. There are many bad habits that happen when you give it, both in chief and in cross-examination. Do not respond to your witness's answers by expressing a comment or opinion. For example, do not thank the witness for the response to your question. I've seen this happen all the time. You ask a question, you get an answer. Thank you, Mr. Jones. It's your witness, and you end up thanking him all the time. I mean, it sounds really stupid. Avoid the habit of saying yes after every answer. Yes. He gives an answer, yes, I see. Yes. It's not a good habit. The worst habit is when you repeat what the witness just said. So you can fall into these bad habits. What I suggest is you understand what these bad habits are, and when you find yourself doing it, just stop it. Okay. Now, you will notice that when leading your witness in chief, it required a great deal of preparation. From your fact analysis to witness analysis to analyzing your case concept, and then you drafted short heads, or you have draft heads of argument. You also have to prepare chronology documents, and then there's the technique. If you observe all of that, you will turn into a good lawyer. But here's the thing. You must practice these techniques. You must do the analysis. You must draft the chronology documents. You must prepare the witness. You must do the witness briefing. And when you get to court, be alive to the best techniques, the techniques that we were talking about here. But practice, improve your technique, improve your confidence. You'll become a good lawyer. You don't become one overnight, okay? And remember, one thing about trials that you can say, they are unpredictable. But the better you are prepared, the more likely you are to be able to handle anything that comes your way that you were not anticipating. And trials are unpredictable. Unfortunately, our judges are very unpredictable. So it's your solid preparation that will help you. Now, let me tell you what happens when you don't prepare and you don't practice the techniques. You'll go to court thinking, oh, I know what to do, but you didn't do the groundwork. And it all comes unstuck. You get a terrible result, and you think, oh, I'm not cut out for this. I think I'll go into the Wills and Estates Department. And I promise you, it won't be long before you start drinking, okay? Because when you go into the wills and estates department, you end up drinking for sure. Okay, now let's go into the most exciting part of a trial, cross-examination. Judges take this very seriously. It is a fundamental part of the adversarial system. It helps the judge to establish what actually happened and is essential for resolving disputes. In other words, it is firstly the evidence in chief puts your version on record. Cross-examination tests that version. It tells the judge whether to believe it or not, whether to discredit it or not. Good cross-examination comes from good preparation. There are no shortcuts. Now, you've heard this thing, that guy, that colleague is a really good cross-examiner. He was born to be a cross-examiner. Okay. Well, nobody's born to be a cross-examiner. I don't care if you have ability, if you have confidence, it boils down to good preparation every time. Remember, the technique may be the same, but the facts are different. Every case is different. That is why you have to do the groundwork. This business of running trials is not for lazy lawyers. If you can't do the work, well, there's another option. You can go do conveyancing, but you'll be bored for the rest of your life. Okay. Now let's look at one of the most important things that judges look for: credibility. Now remember, judges don't know what the truth is, and it is not their job to find the truth. Their job is to work out which is the most probable version. That party who shows that their version is most likely to have happened discharges the onus on a balance of probability. The purpose of cross-examination, one of the main purposes, is to damage the credibility of your opponent's witness. Judges dealing with disputes of fact rely on cross-examination to assist them with credibility. Otherwise, how will a judge know if this is a reliable evidence? Can I use that evidence to make a finding of fact? The judge relies on cross-examination. Now, it must become obvious to you that you can win or lose a case in cross-examination. It's that vital. It's useful to know how judges set about analysis of a witness's credibility. Now, what I'm going to do next, I'm going to show you what judges look for. Now, if you know what judges are looking for, then you can prepare your cross-examination accordingly. Okay. The judge will ask the following questions. Is this witness a truthful or untruthful witness? Now, what that means in real terms is actually another question. Is this witness's version likely to have happened? Now, there are some things witnesses do which immediately create the impression that the witness is lying. The classic is where a witness contradicts themselves in cross-examination and cannot explain the contradiction. And these are contradictions of material facts, not mere detail. When that happens, the witness is found to be untruthful. The judge will want to know is that although this is an untruthful person, this is generally an unreliable person, but he's actually telling the truth this time. Okay, so, or is he telling less than the truth on the issue? Is he telling the truth as he sees it, or has his memory registered events incorrectly? I mean, that happens all the time. That's why we don't want trials to start 6 years after the summons was issued. Memories fade. Was the witness's memory influenced by unconscious bias or wishful thinking or by conversations with others? These are the influences the judge is looking for. Did his memory become fainter or more imaginative with the passage of time? You know, people can make things up the longer it takes. What is the probability that he was genuinely mistaken? Not being untruthful, just mistaken. Is the evidence motivated by any hope of gain, the desire to avert blame or criticism, or misplaced loyalty to one of the parties? This is the whole question of bias that comes in. Is the evidence consistent with what is agreed or clearly shown by other evidence to have occurred? Now, this is very useful. For example, the evidence establishes that on that day the robots were working. The witness comes and says the robots were not working that day. So it's a contradiction of an established fact. The court disbelieves it. Is the evidence self-contradictory or otherwise inconsistent with a previous statement of the witness? Contradictions are a cross-examiner's favorite. If you can show that the witness, contradicted themselves, the witness contradicted themselves on material facts, you can then argue that the witness must be disbelieved. Now, again, remember, the reason you cross-examine the witness is not merely to discredit the witness, but the whole object is to enable you to argue that the witness must be disbelieved, okay? Now, if the witness was taken apart in cross-examination, the judge needs no invitation to disbelieve the witness. But what happens if it's more subtle, where the witness actually makes a good impression? Now you have to go into the nuances of the cross-examination and show that certain aspects of the evidence was shown under cross-examination to be improbable. The judge shouldn't believe it. Now let's look at the basic things. The first thing a judge will do is look at the basics, the source of what the witness tells the court. The judge wants to hear evidence from the witnesses who have personal knowledge of the facts. Now, how often do you find a witness testifying and then the judge says, but wait a minute, how do you know that? Where did you get that from? Were you there? So the judge wants to clear that up. The circumstances which gave rise to the witness becoming involved. How did they become a witness? Okay, this person may have been a random bystander. Okay, so the judge needs to know that. The judge wants to know that the witness was not influenced to come here and testify by someone. How, when, and under what circumstances the information came to be retained by the witness? Can the witness produce a document as support? Now, as time goes, the judge might want to know, but hold on, how did you remember those facts? That's detail that's difficult to remember. How did you do it? Well, my lord, I have a contract or I have a document. Typically, the following questions arise in the mind of a judge. Does the evidence involve something that happened very quickly? Did the witness have enough time to observe and recount? That is what judges call reliability of the evidence. How reliable is the witness? Did the witness have an opportunity to observe, to give a reliable account in court? Has the witness been exposed post-event to misinformation This may distort his recollection. Now, you know what the big problem is these days? It's social media. Social media networks are brilliant at distorting the facts. And by the way, those of you who read a lot would have seen a survey carried out recently. I think the results were published this week, that a high percentage of people actually believe what they read on Facebook or other social media networks. They believe what they read there, okay? So it's become a source of misinformation and disinformation. And somebody, can you imagine, who was a witness to an event, now starts reading what other people say about it on Facebook or on Twitter, and they get influenced. Was there a lack of recollection over the passage of time? Memories fade. Is the recollection supported by contemporaneous notes? Now, contemporaneous notes are brilliant, but how many witnesses do you know of who saw an event and decides, you know what, I better write down what I saw? That doesn't happen. Unless, that is why I say to lawyers, when a client comes to see you, don't just find out what it's about so you can get the bloody office precedent and send out a summons. Get all the facts. Talk to the witnesses now. Take the witness to the scene now, because that's where the contemporaneous notes will come from. That's where the visual evidence will be collected. And that is more persuasive when you get to court. Don't do this 4 or 5 years down the road when you're preparing for trial. It's too late. Is there any bias? Now, when most of you will encounter cross-examination involving identification. Judges will look at physical conditions very carefully, where the issue is identification or a collision or an event of some sort. A bridge collapsed. There was a stampede at a soccer stadium. Now, these are the things that the judges look for. Lighting. Was there sufficient light? Distance. How far was the witness when they made their observations? Is it near enough to be reliable or not? What was the weather conditions? Weather conditions can affect all sorts of things. Road surface to visibility. Weather conditions are very important. Knowledge. Knowledge is very important. What does that mean? Let's say the witness says, I saw one of the robbers. Oh, who is that? Who is the person you saw? Well, it's Mr. Botha. How do you know that it was Mr. Botha? No, I know him. He's my neighbor's son. He grew up in our neighborhood. So there's knowledge, okay? Obstructions. Was there clear view? Now, you know, when you have all these factors, what you're going to do, you're going to use it to structure your cross-examination, okay? So I say, look at that 6-point list. It helps you to handle witnesses effectively. You know what to do to undermine the reliability or even the credibility of a witness. Now, here's a very good judgment. I've given you the reference. It's Stellenbosch Wineries versus Martel. It's a judgment of Nienaber. SCA, look at page 3, paragraph 5. What they did in that judgment is that they created a huge list of factors that judges take into account in making an assessment of the evidence. And I'm going to, those of you who are serious about litigating, read that chapter, okay? It's very important. So what is a judge looking for? Let's look at the things judges look for when cross-examination takes place. Now, you've heard of this thing called demeanor. Demeanor is the physical presence of the witness and their performance in the witness box as observed by the judge. Now, just remember, there are two kinds of judges broadly. There are those judges who believe that demeanor is a good pointer towards credibility. Then there are another school of thought, judges who believe that demeanor is not a proper indicator. Why? Because a person's demeanor may have suffered because his attorney didn't carry out a witness briefing, or the witness was just plain nervous and over anxious about appearing in court. That witness may not be a liar. That witness may just be nervous. That witness may just have forgotten. It doesn't mean they were misleading. So they don't take demeanor too seriously. But there are sufficient number of judges that do care about demeanor. But demeanor is also something that you can include in your argument. And these are the things you look for. This is what judges look for. The expression and bearing. Does this person look confident? Does this person answer clearly and maintains eye contact? Voice. Is there clarity? Confidence in the tone? Then there's this thing called voice fade. Most of you are familiar with it. This is when the voice tends to become progressively inaudible, and the judge has to repeatedly tell them to speak up. So the witness starts talking, and then the voice fades, and the judge says, I can't hear you. That's an indication that the witness is being a bit evasive. Eye contact with the judge and the lawyers, and the response to questions. When you get spontaneous responses, where a witness is genuinely answering the question, judges like that. But when the witness says, repeat that, I didn't understand it, what did you mean by that? And then doesn't answer the question. That's what we call an evasive witness. Does the witness answer the substance of the question? What this means is the witness gives you a response and does not buy time by giving an irrelevant answer or asking you to repeat the question. A hesitant witness, someone who feigns lack of understanding to simple questions, okay? They understood the question, but they'll pretend like they didn't understand it. They take too long to answer the question, asking for the question to be repeated. Look suspicious, cagey, unapologetic. So those are the things that relate to demeanor. But like I say, if you appear in the same division a lot, you'll get to know which judges take demeanor seriously and which don't. But if you are before a judge, you don't know. Or you know the judge, but you don't know what their attitude is to demeanor. Then take demeanor seriously. You can't go wrong. Just take it seriously. Make a note of demeanor. Put that into your final argument. Use your cross-examination with demeanor. You can say, Mr. Jones, you have not answered that question. I'm going to move on and look at the judge. Then ask your next question. Mr. Jones, you constantly look down at your shoes. You never once made eye contact with the judge. And then move on before you get an answer. You see? Mr. Jones, that's an evasive response. But I'm going to move on to the next question. So You see, when someone gives you an evasive response, don't give them a chance to fix it. Okay? Just move on. But put it in your argument. Now, here's the preparation checklist. These checklists are vital. You must know all the known facts. You must know the tribal issue and who bears the onus. You must know what to prove and what to rebut. Do a proof analysis. You must know what material facts you have to prove to discharge the onus. You must know how you will present proof of those facts. Who will be your witnesses? What visual evidence will I need? What documentation will I need? You must know your case concept throughout the trial. Remember, you drafted your heads based on that concept. Carry out a fact analysis. You must know which facts support your client's version and which facts don't support your client's version. Your job in cross-examination is to bring out the facts that support your client's version and undermine those facts that don't support it. Make a list of facts that support your version and make a list of facts that support your opponent's version. It's what we call the good facts and the bad facts. Make sure you did a witness analysis. You did your witness briefing. During witness briefing, you have to tell your witness there will be cross-examination. The lawyer for the other side will ask you questions. This is how they will ask questions. Okay? Take them through the process. Have you checked the paperwork? Are you ready for that? Did you check whether the audio-visual evidence is available and present in court? Have you started drafting your heads of argument? And again, I say, see that the interpreter is there. Okay. Now, to enable you to effectively cross-examine, you must carry out a full fact analysis. This is what you see, if you do a fact analysis, it prepares you for the following, and you can do this. You will know which witnesses to call. You will know which witnesses not to call. Now, just get this straight. The test for calling a witness is not availability. The fact that you have witnesses available doesn't mean you must call them. It's your analysis that will tell you which witnesses are relevant and which witnesses are not. Those that are no longer relevant, and that happens, you start with a set of witnesses, but between yourself and your opponent, you will agree to a number of admissions, and that will make it unnecessary to call those witnesses. You won't call them. You will only have those witnesses ready who are necessary, and your analysis will tell you that. It will tell you what facts to bring out from each witness. Remember I told you witness analysis, name of witness, material facts relevant to the cause of action or defense. You must know what to bring out from your opponent's witnesses under cross-examination. You know, cross-examination is not this mindless asking of questions. You must have a purpose. You must have a target. Every series of questions must go somewhere. And I'll show you how you do that. You must also know what not to ask when you're cross-examining. You know, this is really one of the most important techniques. So often do you find practitioners damage their entire case by asking the wrong question in cross-examination. They get an answer which damages their case. There's a technique to avoid it. I'm going to show you what that technique is. But you must know what to ask. And the rule, if you don't know, don't ask. If you don't know the answer, don't ask. And most importantly, you must know when to stop. Take it from me, lengthy cross-examination does not work, okay? If you stand there and drone on and you're not being relevant, no one takes you seriously. You are going to be accused of having gone to the TEFO school of advocacy. You saw what happened in that Meyiwa trial. This advocate, if you can call him that, spent days on end asking irrelevant nonsense and then felt harassed. Now, here are some useful suggestions. For every witness, you prepare a structure. Write down the facts you want to bring out, and it must be in a sequence. You don't want to bring out facts, even in cross-examination, that's all over the place. You want to deal with a specific fact set, complete your questioning, then move on to the next. So those fact sets you will have written down in a point form that for each witness, here are the things that I want. You don't want to go back and forth and confuse the judge. For each witness, map out the purpose of your cross-examination. In point form, set out what you have to deal with and the order in which you will deal with it. There must be a purpose. And here's a very important point. If it is not necessary to cross-examine, then don't cross-examine. If your opponent calls a witness and the witness does not damage your case, don't ask. Now, I'll tell you what happens, and this actually happens a lot. Your opponent might call a witness who can give damaging evidence, but only in cross-examination. They set you up. They call a witness, well, doesn't do much, doesn't say much, but they're hoping you'll cross-examine because then the witness is waiting for you and they'll nail you under cross-examination. Now, you know what the rule is? If you bring out facts in cross-examination, it's admissible against your case. If a witness does no harm, don't cross-examine. When your opponent says, evidence in chief, my lord, you look up, you stand up, you look surprised. And you say, well, my lord, if that's the evidence, I have no questions, sit down. The judge will know straight away the witness didn't do you any harm. There's no reason to cross-examine. Stay in your seat. When you're cross-examining, don't do this nonsense of writing down questions and then reading it to the witness. Cross-examination is all about persuasion, creating the right impression in the mind of the judge. It's a performance skill. If you stand stiffly in court and you're reading questions out of a sheet, well, the judge gets bored, stops listening. That's when the judge will say, you think you'll be finished by lunchtime. You can't maintain contact. You didn't use your voice. The thing about cross-examination is you can use your voice, okay? You use your performance skills. You only write down bullet points. Where? In your structure, in your framework. And you while you're on your feet, use the thrust and parry of good cross-examination to hold the judge's attention, to get him to start accepting your client's version of what happened. Okay. So here's an example of, it's very bad writing this. Your notes should look like this, bullet points. Time, 8 p.m., dark, no lighting, about 100 meters away, happened quickly, many people milling about, no uninterrupted view, police arrived, chaotic scene. Now, the issue is you want to undermine this person's observation of the scene. Here are the things that you're going to ask. There's your structure, okay? So when you cross-examine, you put the leading question. When you cross-examine, the rule is ask only leading questions. if you don't, what is a leading question? It's a question where you suggest the answer. That also means that if you don't know the answer to a question, you don't ask, okay? So let's look at how using that same structure. You don't ask the witness, what was the time? You put a leading question. It was 8 p.m. Yes. It was already dark. Yes. There was no lighting in the area. No. You were standing about 100 meters away. Yes. Do you see how that goes? Now, here's the trick. When you cross-examine, you don't ask a question. You tell the witness. You are telling the witness the answer. You just want the witness to agree with you, okay? These are the purposes of cross-examination. Let me go through those quickly. To elicit facts favorable to your case. For me, that is the most important purpose of cross-examination. And just get one thing straight, okay? It is not the purpose of cross-examination to break a witness, okay? So that the witness has to be carried out of the courtroom on a stretcher, being a gibbering mess. You destroyed the witness. That's not what cross-examination is about. And trust me, it only happens in the movies. Just get the facts. Get facts to advance your own case. You want to challenge the truth and accuracy of the witness's version. You want to discredit the witness. You want to introduce your client's case or give the witness an opportunity to comment regarding your client's version of the facts. So you are telling the witness what your client's version is. Now, with civil cases, this is not fatal if you didn't do it. But in criminal cases, you have to put your client's version to the state witnesses. If you don't, that can be fatal. But with civil cases, you've got to be smart. You don't say, I put it to you that the defendant was not on the scene. Okay. I put it to you business, you have to stop it, okay? Because it doesn't make sense. It sounds stupid. What you do is you tell the witness what your client's version is. In other words, you're showcasing your client's version. So the judge gets to see what your version is. That's what you do in civil cases. In criminal cases, it's different. You have to put the version. You want to undermine witnesses who are still to testify. Now, how does that work? Well, you know that your opponent is going to call 2 more witnesses. They're sitting outside. You know what they're going to say. So what you do is that you undermine their version by cross-examining this witness. Oh, you say it was dark at the time. Yes. Mr. X is standing outside. You saw him on the scene. Yes. It was dark for him as well, wasn't it? Yes. Okay, so you're undermining that witness already. And I told you, if it's not necessary to cross-examine, don't. If there's no damage, don't cross-examine. Cross-examination can cause more damage. And cross-examination has to be relevant and short. Lengthy cross-examination does not work, okay? Short, sharp, sit down. That's what it's about. So let's look at the method. The first rule is only leading questions. You do not ask the witness, you tell the witness. That's the formula. Don't ask, tell. If you ask the witness, you are bound to get an answer you are not expecting. If you don't know the answer, don't ask. So what is a leading question? It is a question that suggests an answer, a type of question that prompts a response towards providing a predetermined answer. So why do you cross-examine? It is the most important tool in an adversarial hearing. It determines the outcome. It's your best opportunity to sway the judge. But if you get it wrong, it can be disastrous, okay? You know, I've seen bad cross-examination where the lawyer actually strengthened the evidence in chief, did not undermine it, but made it even better. I mean, that's a fool for a lawyer. And this is the technique. First, think of the answer, then tell the witness. Not ask the witness, tell the witness. Tell the witness what the answer is. You do not ask open questions that can be answered in more than one way. You see, the problem with open questions in cross-examination is that it will elicit an answer that you were not expecting. You lost control. Or, even worse, when you ask an open question, you might get an explanation from the witness that you were not expecting, okay? When you use short leading questions, one fact at a time, you control the witness. And that way, you control the evidence. The reason why you want to control the witness is because you want to control the evidence. Once you use an open question, it is impossible to know what the response is. Then you lose control. You also lose control when you ask a question and you don't know the answer. Now, that's a fool for a lawyer. The leading question controls the answer because you see, you're not asking the witness, you're telling the witness. Ideally, you should be looking for a single word answer, yes or no. So let's look at an example here. You want to bring out where the witness was on the 16th of July. So in chief, you will ask, where were you on the 16th of July? I was at my place of employment at Acme Bakery. Now, those are not leading questions. These are open questions. This is how you ask in cross-examination. You were at your place of work in Bramley. Yes. You were at Acme Bakery. Yes. Notice now that you are not asking the witness, but telling the witness. Do you see? That's how it's done. You're telling the witness. The technique is first think of the answer, then put the leading question. So think of the answer and then tell the answer to the witness. That's good cross-examination, okay? Now, it will be a mistake if you ask this question. Let's say it's a collision. Mr. Wilson, what was the weather like at the time of the collision? Now, that's not a leading question. You're asking an open question. So now the witness is going to explain what the weather was like, but they will give you the description of the weather that suits their version, not yours. Okay? Look, sometimes you get lucky, you get the answer you want, but don't take the risk. Ask a leading question or a series of leading questions. And this is what it should look like. In page 34, you will see of your materials, you'll see how the cross-examination goes. Now, the lawyer's case concept or the client's version of what actually happened is that the driving conditions were poor, visibility was bad, the road was wet, and it was getting dark. This is what the lawyer will present in argument. That's now you, the defendant's lawyer. The lawyer was not tempted to get the conclusion from the witness. Now, here is a problem with cross-examination. I told you, ask leading questions and tell the witness what the answer is. Many lawyers get tempted. What they're tempted to do, they'll get the answers they want, but then they want to ask the witness to give them the conclusion. So there's an example. Mr. Wilson, it was raining, yes. The road was wet, yes. The driving conditions were dangerous. Do you see? That's the wrong question. What you want is to bring out that it was raining, that the road was wet. The conclusion that the driving conditions were dangerous is the argument you're going to make. You're not going to say, you're not going to get this witness to say the driving conditions were dangerous. Now, if you say to the witness the driving conditions were dangerous, you don't know the answer to that question. You can't assume that because it was raining and it was wet, the witness will think or will assume that the conditions were dangerous. Wrong question. You know what could happen? You'll say the driving conditions were dangerous. The witness will say, well, no, it was raining, but you could drive safely. You just undid your cross-examination, okay? Firstly, the lawyer didn't know the answer to that question. Yes, it was wet, but the road was safe to drive. That's the answer you could get. So your cross-examination that preceded it, which was good cross-examination, is all gone down the tube. That answer will damage your case. It is so easy to mess up by just using the wrong question. Secondly, never ask the witness that one question you are tempted to ask. Once you get the answer you want, move on or sit down. The temptation is to try and get the witness who is being cooperative to agree with your conclusion or argument, okay? Right, for example, you're dealing with identification. The witness identified your client on the scene of a robbery, and you go, Mr. Mokoena, it was 8 o'clock. Yes. It was already dark at the time. Yes. You were standing across the road from the jewelry store. Yes. You were sitting in your car. Yes. You did not have a clear view of the jewelry shop, which was behind you. Correct. There was a lot of people milling around. Yes. You told the judge that you can't remember what the defendant was wearing. Yes. You are unable to recognize my client on the scene. Stupid question. You don't know the answer. The witness will say, no, but I knew it was him. I saw him clearly. So you've undone all your cross-examination. What you did is that you wanted to get the conclusion or the argument from the witness. For God's sake, don't do that, because they will not give you that answer. They will undermine you the first opportunity they get. So when you've got the facts you need to argue that in the circumstances the identification is unreliable, that's what you're going to do. But now let's say you asked the stupid question. He said, no, I saw it was him. Now you're arguing that the visibility was poor, he was too far from the scene, he didn't have a clear view. My lord, he's an unreliable witness. The judge will say, but hold on. You put that question to the witness and he said, no, he's sure he saw your client there. You see, that's what's going to happen. So don't just leave your conclusion for the argument. Don't be tempted by a cooperating witness to get that out of them. Okay. Okay. The lawyer did not do this. It was 6 in the afternoon. Yes. It was getting dark. Yes. It was becoming misty. Yes. Visibility was poor. Do you see? There's a big problem there. What a stupid question. It was about 6. Yes. It was dark. Yes. It was misty. Yes. Now that's where you stop. Now you can argue that visibility was poor. But if you ask the witness, visibility was poor. No, it was not so bad. I could still see clearly. So what happened? They just destroyed your argument. Don't do it. The best of lawyers can be tempted to ask that one extra question, seeking affirmation from the witness who appears to be giving all the right answers. Don't be tempted. Reserve the conclusions and assumptions of fact for argument. You will say, my lord, it was Mr. Wilson's evidence that it was a rainy day. The roads were wet. Visibility was poor. The driving conditions, my lord, were treacherous. Do you think when you cross-examine Mr. Wilson, he's going to agree with you that the driving conditions were treacherous? Of course he won't. That's argument. He'll give you a dangerous answer. Go to page 37 of the notes. You'll see an example of cross-examination for identification. Now, what you will see is that there was a structure. Knowledge of the client by the witness Ndaba. First time he sees the client. The cross-examination would look like this. Mr. Ndaba, you don't know my client. No. You never saw him before. No. According to you, you saw him for the first time on that day. Yes. You only saw him for a fleeting moment. Yes. You see, I got what I want. I didn't say, well, then you must be mistaken that it's my client. You'll say, no, I know it's him. I saw him. Okay. Distance from the scene. Position of Ndaba relative to the scene. The lighting. Detailed observations. Did not see clothing. Did not see the man doing anything. Okay. You'll see you'll see some case studies on page 38. Now let's look at what you can get out of this. The lawyer was in control. Why? Because he only asked leading questions. The lawyer maintained control because he used the technique of one question, one fact. No multifaceted questions. All the witness had to do was say yes or no. There was a structure to the question. The lawyer proceeded from one fact set to the next. The lawyer took each set according to a planned structure and then built up the questions without giving the witness any opportunity to wriggle out. The witness was not asked to describe what he saw. The witness was told what he saw, and that's important. Mr. Ndaba, what did you see on that night? I mean, what a rubbish question. You're cross-examining. You don't know what he's going to say. He will repeat what he said in his evidence in chief and make it look even stronger. You must tell the witness what he saw. Don't ask for any conclusions or argumentative matter. Leave that for your heads of argument. The material facts must be brought out to support your version. The questions must be asked in a polite manner, no sarcasm, no insults, no gratuitous attacks on the witness. Now, just let me tell you one thing. Judges hate it when you are impolite towards witnesses. Remember that as far as the judge is concerned, this witness came to help the judge. The judge is not going to allow you to insult the witness, to badger the witness. You know, if you want the judge to be on the witness's side, then you must be impolite. Then badger the witness, insult the witness. It doesn't work. It only works in the movies. It doesn't work before a judge. Let's look at another common mistake. Look at these questions. Mr. Ndaba, you do not know my client. Yes. You never met him? No. Before this incident, you did not know my client? No. According to you, you saw him for the first time on the evening of the incident? Yes. then Mr. Ndaba, you cannot say you saw my client. You could be mistaken. Do you see? You just made a bugger up, because that is a matter you present in argument. Do not try to get the witness to agree with you. Firstly, you don't know the answer to that question. The witness can say, no, I know it's him. I saw him clearly. You will not recover from the damage, for sure. Your job is to obtain the facts that advance your argument at the end. So once you got the facts, move on. Okay? Just go away. Now, previous inconsistent statements are important. I dealt with it in your notes on page 43. I've run out of time, but I'm going to say something about re-examination. There's one rule about re-examination, and that rule is don't re-examine. If you prepared well, you led your witness in chief, you did a good job, you got the facts that you want, it's usually unnecessary to re-examine. Judges like it when you stand up and say, no re-examination, my lord, and you sit down, looking confident. If you have to re-examine, only achieve the purposes of re-examination. If there was a material fact which required clarity from the cross-examination, bring out that clarity, and that's it, do no more. Do not introduce anything new. Do not introduce new facts. If you do all of those things, you are going to undermine your own case, okay? And it just creates a very bad impression on the judge. The best impression is when you say, with confidence, no re-examination, my lord, and sit down. Now, you will notice that I was giving demonstrations here. You have to use your voice. It is performance. You have to, this is a performance skill. Sorry, Betty. Betty, are you there?
I'm here, Judge.
Have you got questions?
There's two. I've sent them to you.
You sent them already?
Yes.
Okay, I'm going to get to them now. If there are more questions, you can send them. Oh, there we are. From Chris van Wyk, your opponent asked leading questions. Is it better to leave him and later argue probative value of the evidence, or object and maybe assist him to lead better evidence? Oh, no. The one thing you do, what you don't want to do is assist your opponent. You're not there to assist your opponent. You're there only to assist the judge. Now, that's a good question because it comes up all the time, and it's something that you need to think about. The one technique is that if your opponent asks a leading question, you just leave them. Let them ask. Because what happens with lawyers, if they get away with one leading question, they're tempted to ask another leading question and another one. Now, I must tell you, I attended a trial when I was a young advocate. I was in the High Court in Johannesburg. There was a very big case involving an air crash, and some of the bar's finest silks were appearing. And I was listening to the one silk. So I thought, I mean, lots of us juniors who were available, we went to listen because it was the legal event of the time. So we're sitting in the gallery, and there's the silk asking one leading question after another. Judge said nothing. The opponent, who is a silk, said nothing. And I thought, but hold on, this is wrong. He's supposed to object. The judge was supposed to stop him. Well, this went on for a while, and then the silk on the other side stood up slowly and said, my lord, may I just say how well my learned friend is giving evidence? And he sat down. And that was the end of it. because that's what it is. Now, let's look at this more carefully. You can use the technique where you let them dig a hole for themselves, let them ask leading questions, and in argument you say, you cannot accept that evidence. It has no probative value because the evidence was given by my learned friend. And then it's highly effective for you to say, well, Lord, let me read this to you. And then read to his lordship all the evidence that your colleague gave. That works very effectively. The other method is to object. Okay? That has two advantages. Firstly, it undermines your opponent in the eyes of the judge. The judge is thinking, yeah, I mean, he knows he shouldn't be asking leading questions. I'm not going to take him too seriously. That's one advantage. The other advantage is it can settle your opponent. And that's always a good idea, is to unsettle your opponent. So now, what you don't want to do is be a jack in the box, where your opponent asks, you stand up, objection, sit down. Opponent asks another question, objection, you become a nuisance. Where your opponent asks a leading question that does no damage, just leave it, let him carry on. But when he asks a leading question on a material disputed fact, that's when you say objection, leading question, okay? Now the judge will say sustained. You've scored a good point, because it's never a good idea to have objections being upheld against you. Okay, so that's how you will deal with that. Another question from Brigitte. Isn't your duty to put your client's version to each witness? Can you nonetheless sit down if their testimony did not hurt your case? Correct. If a witness does not hurt your case, no need to cross-examine, no need to put a version. Even in a criminal case, if a witness testifies and does not harm your client, the accused, or places no evidence on record that could harm your client, say no cross-examination. Don't stand up and put a version. I've seen that happen in court. In a robbery, where the witness described the whole robbery, but didn't say that the accused were present. There were 4 accused. And the idiot representing one of the accused stood up to tell the witness, I put it to you that my clients were not there. The witness looked and said, no, they were there. Number 1 was doing the following, number 2 was dressed like this, and number 3 was doing the following, and he put them all on the scene. South Africa's dumbest lawyer, okay? So only cross-examine, only put your version if that witness hurts your case. Otherwise, leave them alone. No cross-examination. Judges love it. They know you're a good lawyer. But that comes with preparation, okay? You must prepare. Any other questions, Betty?
I sent you another one.
Oh, okay. Johan, any advice on how to handle a prosecutor who objects against my questions in cross-examination and his magistrate? You can't ask a witness, for example, why he says the car was blue and the previous witness said it was green. You would object and you would be stopped from asking these type of questions. Listen, I wrote a whole chapter on difficult magistrates and judges. Let's say this happened. A witness testified that the car was blue, and now this witness says it was green. Now, it depends on how you ask the question. You don't say to the witness, you can say to the witness, what was the color of the car? That's not the way you ask, cross-examine. So now he says it's green. The previous witness said it's blue. You put a leading question. Mr. X, who just testified, said it was green. That's it. Before any objections can happen, the answer is given and it's done. It's there on record. Magistrates cannot stop you from asking questions. There's a very effective way of dealing with a judicial officer who interrupts your cross-examination. Now, firstly, if a judicial officer interrupts your cross-examination, it may be because you are totally irrelevant, you are being of no use, and they are trying to tell you it's time you sat down. But if you are asking relevant questions and for some reason they interrupt you, the technique is to stand up to it, okay? Now, please get this straight. Judges and magistrates are not gods, okay? They are like us. We all human beings. They just sit at a higher level for purely geographic reasons. They're not higher human beings. They can't kill you. They can't zap you with lightning or something. You are not to be afraid, but you must be respectful. You tell the judge, your lordship has interrupted my cross-examination. If your lordship will only allow me, I will conclude these questions. Emphasis on the word allow, because it's now suggesting that the judge is not allowing you, or the magistrate is not allowing you. That now you are in unconstitutional territory. You're now telling the judge, my client's not getting a fair trial. As soon as you do that technique, they stop. They'll sit down and let you carry on. As for prosecutors, if there's a technique they use, they interrupt you when you are damaging their witness. So they come up with spurious interruptions and to try and unsettle you. Don't waste time. Stand up and say to the judge, my lord, if my learned friend will allow me to cross-examine, I could finish. Or say, my lord, my learned friend's spurious objections are not going to protect his witness. Your lordship will allow me to carry on or to continue to ask. That's the technique. And you won't have a problem. You've got those notes that I gave you. What you have in that note, in my notes, I extract from this book. Some of you are familiar with it already. It's called Trial Advocacy, The Art of Persuasion. I wrote this book. It is all you need to prepare yourself to be a good trial lawyer. Then what you have to do is go and practice the technique. Do the work and practice the technique on your feet in court. You can be a first-class trial lawyer. And there's nothing better than to be a first-class trial lawyer. Nothing beats it, okay? Well, if there are no more questions, Betty, I think we could conclude.
We are done, sir.
Okay. All right, everyone, thank you for attending. I hope this was useful. And like I say, practice the art. Okay, thank you. Well, I must say hello to my friend Ismail. Ismail, it's good to see you.